Hi, everyone. Welcome to our first LinkedIn Live. We're moving the format of our CWC, our Chatting with Charlie, from our webinars to our LinkedIn Live. So this will be a very, very short format. So probably about 10 to 15 minutes. We're asking that you send us your questions, and then we'll do another podcast where we'll actually answer those questions. And then what we're going to do today is summarize the March Visa Bulletin. You're going to get Early's live reactions, basically, from the newly released Visa Bulletin. Next week, we're going to release our first episode of the Bulletin podcast, which is essentially a spinoff of our Chatting with Charlie. And we're going to go into a deeper dive into the Visa Bulletin predictions for April and the rest of the year. So that podcast will be available in video form on YouTube and Spotify, as well as audio-only format on all the other podcast platforms. So be sure to follow WR Immigration on LinkedIn or subscribe to our newsletter for more information on our episodes that we're going to release in our podcast format, and then also our LinkedIn Live. We will do an expanded Q&A podcast episode. So we encourage everyone here today to add your questions, like I said, in the comment section, or you can send us a direct question on LinkedIn, and we're going to address them in the upcoming podcast. If you're watching the recording back, please drop your questions in the comment or send them to us directly. And again, I'm Sharina Garcia. I'm a strategy and innovation partner with WR Immigration, based in the San Francisco Bay Area, but currently in Chicago for the American Bar Association Tech Show. And we have here with us Charlie Oppenheim. So Charlie, why don't you introduce yourself?
Good morning. Again, Charlie Oppenheim, former Chief of Immigrant Visa Control at the State Department for the past 23 years prior to my retirement. I'm currently the Director of Visa Consulting with WR Immigration.
And then we have Laura as well. So Laura, why don't you introduce yourself as well?
Hi, I'm Laura Blanears. I am a corporate immigration attorney at WR. Normally in Santa Monica, but today with Sharina in Chicago. So if you're in Chicago, drop us a line. We'll meet you for coffee, a cocktail. We're here for the ABA Tech Summit. And I've been practicing corporate immigration law for 10 years. Call me when your corporate leadership is looking to hire or recruit for a national talent.
Great. And so, all right, now to the meat of it, Charlie. Let's talk about this Visa Bulletin that just came out. So one of the things we noted, of course, which you had already predicted, was for employment-based, they are to use the final action dates, right? So not Chart B dates for filing, but the final action dates. And
Sure.
Charlie, you had predicted this before, right?
Yes. Everybody should be looking at primarily at the Chart A final action dates. The Chart B dates are where the State Department believes the final action dates will be in 8 to 12 months, and those Chart B dates are used for potential early filing of petitions with the USCIS.
But USCIS is saying right now that we should use the Chart A, the final action date.
Chart
This
A
came out on February 12th.
Right.
Yeah.
And what has happened, USCIS has determined that the amount of filings that have already occurred is sufficient to meet the demand for numbers for this current fiscal year. And this typically happens, as I mentioned last month, typically they allow the dates, the application dates to be used typically between January and March before they cut off, and they've now cut them off. So for the remainder of the year, strictly the final action dates listed in Chart A will be used for filing for adjustment of status.
So Laura, as our clients are planning, what's your takeaway that you want to tell them about, like when Chart B is not used and we have to use Chart A for employment based?
Well, I think, seasonally, we know that Chart B cuts off around this time. And if you're listening in, Charlie predicted it last month. So, I think you've been working with your corporate immigration attorney to be tracking your perm filings, like anything you filed about 11 months ago, you can expect DOL to certify a perm in about 12 months. So you just can know those certifications if they have previously existing priority dates. Unless they've got a final action date, they're not going to be able to move forward with an adjustment of status until October. So having those conversations with those folks that are expecting perms from now until September, letting them know that if they have a final action date, they'll be able to move forward, preparing them with the information they need to have all updated documents. If their final action date or prior date is not current for final action, still let them know about what's needed for the adjustment of status, but prepare them that they're not going to be able to move forward even if they have a date for filing priority date.
Yeah. So basically, they should just get all their birth certificates, all of that stuff ready to go, right?
So yes, a surprising number of clients don't keep track of their passport expiry. So having their HR remind them that that is their responsibility as a foreign national in the U.S. They do need to maintain a passport for compliance, but also for future applications, they need a valid passport.
Okay. All right, Charlie, let's walk through this. So employment-based first preference, rest of the world. Did we see any changes?
There were significant changes in each category. The employment second, third, EW, and employment fourth preference categories all advanced for the month of March. And so this has been a pattern. They've been advancing slowly since January, and this may continue as the State Department, in conjunction with USCIS, is getting a better feel for number use and what demand is likely to be in the coming months.
Okay. And then how about our China and India born?
China, the only final action date which advanced was the employment first preference category, which advanced by 2 weeks. This is pretty much what we had been predicting in earlier telecasts. And we may see some slow movement continue in the first preference category. For April, I would not be surprised if we see a little movement potentially in the China second and third preference categories, but we'll kind of have to wait and see.
Okay. And then I noticed for China, again, EB3 is a little bit faster than EB2. So Laura, Charlie, what are we doing there? What's going on there?
This is always a tricky situation. We see it both with China and India, where people do upgrades and downgrades. So it's a little bit of a dicey situation to predict which do you want to up or downgrade. And I'll let Laura speak to that because she sees that more often.
Yeah, and I mean, in the EB2 and the EB3, unless you're holding a national interest waiver in the EB2 category, you're going to be needing to chat with your corporate sponsorship and whether it's within the policy to upgrade or downgrade. Given at this point that we're only eligible to file under the final action, if you've got a downgrade available under your policy, it might be something worth looking into given that you could get a final action. So at this point, it might be something you're looking into, but the things you're going to need to talk to with your corporate immigration partner is whether your policy allows it. And that if you're managing the corporate immigration policy, you'll want to be really careful with if you're going to allow it, knowing that these things can reverse in October, that you can see the EB2 race ahead. And then you'll be in the situation where that employee will look for the upgrade. So just be mindful if your policy allows these types of upgrade downgrades, whether you're going to allow multiple, because that could be the situation come October.
And you bring up a good point about the national interest waiver, because we have right now, national interest waiver is hot, right? And we're getting a lot of approvals. And so now we're actually getting requests from our clients to do the national interest waiver and do the perm because they want to do the EB3. So are you seeing that too as well, Laura?
Yeah, absolutely. Again, this would be when corporate immigration policies permit 2 pathways for sponsorship. Some do, some don't. The national interest waiver pathway is an interesting one to explore because we are seeing qualified candidates. We are seeing approvals, and it is much faster than going through the perm. It's not relying on a labor market test, and you can premium process. Although come April 1st, this premium processing timelines are going to extend to business days. But in any event, it is much faster than the perm process. So for talented individuals, exploring both pathways is good because it allows them to have an early approval potentially in the EB2 and then the backup. So a nice conservative route to ensure they get an I-140 approval for likely H-1B extension or just that spot in line with the priority date.
Okay. And then Charlie, how about India-born folks? What are we
For India, like China, the only change in dates was in the employment first preference category, where the final action date advanced 1 full month to October 1st of 2020. I think that any movement in the India dates is going to be much slower through the remainder of the fiscal year. And the reason for that is India, as with China, is subject to strict per country limit this year. There are not the availability of otherwise unused numbers under the worldwide limit, and that fact is going to severely limit the forward movement of the India and China final action dates.
And again, we saw here as well that EB3 is a little bit faster than EB2 for India. So we also have that downgrade situation as well going on. Anything else you want to share, Charlie, about the March Visa Bulletin?
No, I think it is important. People in India and China categories may want to monitor the rest of world movement of the dates, because the dependent on whether India and China will have access to otherwise unused numbers depends entirely on the fact of whether the rest of world second and third preference categories have final action dates. As long as there's a final action date in rest of world second and third, then the China and India categories will be subject, like I said, strictly to the per country limits. If the rest of world were go to current, that would mean there's unused numbers, and that may benefit primarily the India applicants.
Okay. Laura, any other takeaways you want to share?
Yeah, we saw USCIS put out a sort of annual summary noting that they used for the second year in a row all employment-based immigrant visas, and that number was 192,000, if I'm not mistaken.
Yeah, 192,000.
And so kudos to them for using all of them. But my question to Charlie, and we were chatting before this, was, what happens when they don't use all the immigrant visas in a year? Like, do those roll over, or if they've used them all consecutively for the past 2 years, what's happened in prior years when they don't?
If there are unused employment numbers under the annual limit, they quote fall across for consideration in the family sponsored category limit for the following year. Unfortunately, those numbers are typically lost. They do not benefit the family sponsored categories. It's important to remember that the fact that they used so many numbers last year, the limit this year is down to approximately 161,000. So, roughly 30,000 fewer numbers. And the annual limit for fiscal 2025 is likely to be more closer to the 140 to 150 range. So we've come off the peak years of high limits in the employment category, which were the result of unused family numbers during the COVID times. The unused family numbers from the previous fiscal year are added to the employment limit, and that's resulting in the 161,000 this year versus the minimum of 140,000.
Okay. Well, I want to thank you both for our very first LinkedIn Live chatting with Charlie. So thanks to the audience for joining today. Remember to share your questions in the comments or send us a direct message, and we're going to answer them in the upcoming podcast of the Bulletin. We will also go over some of the family-based, because we get a lot of questions about family-sponsored green cards as well. So we'll cover that in the Bulletin. So be sure to follow WR Immigration on LinkedIn for updates on the Bulletin podcast, and then future Chatting with Charlie live streams, and then more. And then lastly, our colleagues David Fulmer and Rich Yem, they're doing a LinkedIn Live tomorrow on H-1B alternatives. Important that you tune in at 10 a.m. Pacific, 1 p.m. Eastern. So we'll drop the link in the comments. So thank you to Laura and Charlie for joining me today in our LinkedIn Live session.